Dear ladies and gentlemen, the lecture's title, Wirtschaft und Recht nach der kulturwissenschaftlichen Auffassung, makes a not entirely unpretentious allusion to the work of Rudolf Stammler, who spoke of a materialist conception of history, materialistische Geschichtsauffassung, during his time. Weber offered a scathing criticism of Stammler, who committed all of the world's conceivable categorical errors at once, and surpassed himself yet again in his sharpness and intellectual disgust in the unreleased marginal notes for Stammler's book that I had the pleasure to study one day. This would arguably play an important role in Weber's economy of writing in his Schreibökonomie. However, I do believe that correcting this in the sense of replacing it with a cultural scientific view, kulturwissenschaftlich is translated in this way, as favored by Weber, never occurred in a systematic manner. Surely his study of Protestantism can be interpreted as an example of that kind of study, analysis of economic activity from the viewpoint and the perspective of the Kulturwissenschaften, its motivations and its structures, in which a culture of capitalism emerges, namely as the spirit of capitalism that rests upon the inadvertent consequences of religious action, as we know. But the study of Protestantism simply fails to take a look at the law. In the studies on law, on the other side, which were once received as sociology of law, die Rechtssoziologie, and have since been edited as law in this blue volume. I think I must have even an image of that. That's a real book. In any case, in the historical and critical edition, law's relation to economic law specifically is rather poorly developed, despite the fact that the chapter on economy and society was at one point designed to be an anti-Stammler. This can be read in the MVG 122.3 volume, that is, if you're willing to go to the trouble of struggling through this collage pieces, jungle edition, as I would like to call it. By the way, in dem Journal Rechtsgeschichte findet sich eine solche Analyse unter dem Titel Das Collagenwerk schon 2003 oder 2004, wo das Argument, die Éloge de la Variante und die Art und Weise, wie dieses Grundwerk der Soziologie und zugleich auch der Beziehung zwischen Wirtschaft und Recht dekonstruiert werden kann, glaube ich, in sehr knapper Form einmal analysiert ist und dann auch in diesen Band Eingang gefunden hat. This lecture will first recollect the controversy between Weber and Stammler in order to see which research questions can be gained from their dispute that have been lost in purely methodological debates at the time. Subsequently, several thoughts on how law and economy can be analyzed as cultural, scientifically tangible phenomena will be discussed, to ultimately determine how the favored formula, if not campaign slogan, culture matters, can be applied to the fight for the law, den Kampf ums Recht. To say it very simply, there will be three parts. The first part with a look back to the methodological reflections of Weber with reference to Stammler. The second part, a more general view how the sociology of culture may approach economy, economic life, in a way that makes it, on the one side, critical for a purely and sometimes poorly economic paradigm look at economic life, and on the other side to see where it may lead our debate between law and economy through the lenses of cultural studies. That will constitute the third part, where I try to bring in the debate that we can read now nearly everywhere as a new kind of sociology of economy. This has become a long and big strand in sociological debates during the last years. It is a methodological dispute that draws Weber back to law, and draws back means simply that after his advances in nationalökonomie and his personal crisis that led him and forced him to leave his job, and then serves as a methodological and substantive motive driving the elaboration of Weber's outline contribution. How could a methodological dispute fulfill this important function that can be traced down to the details of the argumentation in the presently edited text on die Wirtschaft und die Ordnung? This should be very important for our debate, of course, this kind of text. To such an extent that Weber wrote to Kantorowicz in 1913 about his project on interpretive sociology, it is the attempt to remove all that is organicistic, stammlerhaft, over-empirical, valid, and to conceive of sociological constitutional studies as the study of pure empirical, typical human action, soziales Handeln, oder Gemeinschaftshandeln, as Weber called it during this period. Here Weber could build on the latter's agreement that Stammler's work lacked intellectual value, an assessment that Kantorowicz had offered in his review of Stammler's Die Lehre vom richtigen Recht. His critique was in fact so strongly formulated that Weber set his methodological differences to Kantorowicz, that he had, of course, Kantorowicz was the leading figure of the Freirechtsschule, pretending to be able to sociologize, so to say, jurisprudence. And this was, of course, against Weber's basic methodological convictions. And he proclaimed that regarding the present question, I'm certainly of your opinion and very pleased that in the continuation of my analysis of Stammler, I have been relieved of the task of also quelling the nonsense about correct law, richtiges Recht, through the thorough work of someone with a greater calling. It was not only Weber who had issues with Stammler. All other founders of sociology, including Simultanius and Durkheim, through the Année Sociologique, dealt with Stammler's views in a fundamental way. Streams of thought on the philosophy of law and legal theory at the turn of the century also remained, so to say, fixated on Stammler. This can be seen, for example, in the works of authors such as Emil Lask. We had even a seminar about his work during our conference about the normative complex 3 or 4 years even ago, and Gustav Radbruch. The latter, writing to Kantorowicz about the first edition of Stammler's Wirtschaft und Recht, stated, "Upon repeated reading, I consider this work very excellent. In any case, you should read it." So, you see, ambivalences in judging this work. It is only through Weber's critique, which he describes to Kantorowicz as felicitous, trefflich, wohltrefflich, that Radbruch arrives at a more critical view of Wirtschaft und Recht. By looking at Stammler's contribution to Hindenburg's Handbuch on Wesen des Rechts und der Rechtswissenschaft, it became apparent that one did not need 2 thick volumes to express these thoughts. The verdict by philosopher Vorländer, on the other hand, is unreservedly positive, for he believes that Stammler succeeded in his primary objective to create the basis for social philosophy as a discipline. How did Stammler's views become so important yet so damnable to Weber? And what is the importance of Anti-Stammlerism for Webers Die Wirtschaft und die Ordnung, as well as for die Entwicklungsbedingungen des Rechts that was transmitted under the title of his famous Rechtsoziologie? In an incredible polemic appraisal of Rudolf Stammler's work, who, by the way, is represented in this image by way of reading in the margins that Weber himself has noted into his book. Unfortunately, he could never read this one. But if you go downstairs on the second floor, you could verify that he really, in this image, he is reading the critique of Weber to his own work. It's, of course, a fantasy product, an imagination. But I could imagine that he would then, and we had to read about the monstrosity of the book, das Monströse dieses Buches, and admonishes the use of a thicket of false truth, half-truth, incorrectly formulated truth, and untruth hiding behind unclear formulations. This is very difficult to surpass. It is really the extreme negation. He continues by criticizing scholastic false conclusions and sophism, which render dealing with the book, due to the mostly negative result alone, an unpleasant and at the same time endlessly tedious and extremely rambling affair. Wollen Sie das im Deutschen mal hören? Es hört sich noch viel schöner an. Also, wenn man nicht so ganz tief im Englischen drin ist, was mir Candice Carriston freundlicherweise so schön ins Englische übersetzt hat. Dickicht von Scheinwahrheiten, Halbwahrheiten, falsch formulierten Wahrheiten und hinter unklaren Formulierungen versteckten Nichtwahrheiten, scholastische Fehlschlüsse und Sophismen, welche die Auseinandersetzung mit dem Buch zu einem schon die wesentlich negativen Ergebnisse wegen unerfreulichen, aber unendlich lästigen und höchst weitläufigen Geschäft machen und so weiter. Also normalerweise würde man sich danach duellieren. Das hätte Weber sicherlich mit Freuden aufgenommen, eine solche Aufforderung, auch wenn er sie am Ende vermutlich nicht realisiert hätte, wie wir aus vielen anderen, zahllosen anderen Beispielen wissen. Ich will Sie damit nicht länger langweilen. What is really the main point is that according to Weber, Stammler has done principally, and during the 2 volumes especially, committed one major fault. And this fault was to make no clear distinction between is and ought, be and should, and that in defining and describing economic life as being ruled by norms and structured by norms, structured by law, as if law was causal for effects in the economic world, this was the absolute main fault and categorical mistake that Stammler took, and that is why, for him, it is a methodological debate on the one side. It is unfortunately fixed on the topic of economic life, so that the whole question what then economic life would consist of had been thrown away for the sake of methodologically criticizing what this Stammler was unable to understand. So you see, there is a real problem in that the methodology was so in the foreground of the debate. So I stop here. It might be interesting for some of you to have a look into Stammler again, who had an enormous success around the world, as I said, but who in his kind of causal attribution or attributing causality to law and norms and normative orders in understanding economic life made a mistake in Weber's imagination and in Weber's critique of making a melting up between is and ought, be and should, etc., so that this, for fundamental reasons, would be absolutely useless. And so, when Weber was more or less forced by his editor, Siebeck, to write his major work that we know as Wirtschaft und Gesellschaft, perhaps his religious studies are also a kind of Hauptwerk, and there has been a debate, especially brought forward by Tenbroek about this question, whatever and however and how we might resolve this problem. It is clear that the starting point for writing this overwhelming story about modern societies had in its background the debate with Rudolf Stammler. One has just to know this. So one has also to understand that for the Weberian approach, it had been so important to start with a difference of economy and law, and to look at the relationship of economic structures and normative orders. In the aforementioned part of economy and society, die Wirtschaft und die Ordnungen, there we can find indeed a debate about the relationship of the two under the title of a critique of materialist and spiritualist causality of law and economics. This is it's the third section of Die Wirtschaft und die Ordnungen, entitled more precisely Bedeutung und Grenzen des Rechtszwangs für die Wirtschaft. There, the relationship between law, conventions and manners is described as not genetic but functional. Weber states that legal order is not empirically valid in reality as a result of the existence of the coercive apparatus, but because its validity has been lived and practiced as manners and conventions usually disapprove of flagrant deviations from behavior conforming to it. Soll ich das mal im Deutschen auch lesen? Manchmal ist der Weber im Deutschen doch noch einfacher als im Englischen. Auch da hat man da manchmal, trotzdem muss man zweimal lesen. Dass die Rechtsordnung nicht etwa infolge des Bestehens der Zwangsgarantie in der Realität empirisch gilt, sondern deshalb, weil ihre Geltung als Sitte eingelebt und eingeübt ist und die Konvention die flagrante Abweichung von dem ihr entsprechenden Verhalten meist missbilligt. So, there it's very clear. Weber's argument is directed versus a coercion theory of the law. It has to do with acceptance and routinization of behavior when current behavior, everyday life behavior, is in correspondence with normative orders. As Weber extends the concept of law to non-state law, very important for his time and for our debates today, expands the cosmos of normative orders by including conventions, manners, and customs, and further constructs an interlinked validity construct of law, manners, and conventions, his preference for codified state law as a guarantor of a law that suits the activities and developments of the market becomes clear. For, quote, the increasing intervention of codified orders is but one characteristic component in our observation of the processes of rationalization and societization, whose progressive reach into all communal action we will need to follow in all areas as a key driving force of development. So the argument is, normative orders have and play an important role by way of market structures that need predictability in the end in order to bring more rational or more rationality into societies. This is linked together, and this is one of Weber's main premises. Weber thus draws upon the pure sociological legal doctrine as an analysis of normative orders in the wake of the process of rationalization. This process is understood as a development that also produces rational law, although Weber had been arguing since the Soziologentag that economic and legal orders were in principle functionally independent of each other. It is particularly economic forces that Weber holds responsible for the development of rational law. The quote, "The universal rule of market societization demands, on the one hand, that law functions in a predictable way according to rational rules. On the other hand, the broadening of the market, which we will come to know as the characteristic tendency of market societization, by virtue of its inherent consequences, favors the monopolization and regulation of all legitimate coercive power by one universalist coercive institution through the dissolution of all particularistic coercive constructs of estates and other typically resting on economic monopolies." So this, of course, to say this in German, wollen Sie es lieber auf Deutsch nochmal hören? Ja? Also auch da ist es einigermaßen schlimm, aber man hatte bei Parsons immer den Verdacht gehabt, dass er direkt Weber übersetzt hätte und dann auch noch in ein schlechtes Englisch und dann das Ganze auch noch substantiviert hätte. Und dabei kommen natürlich fürchterliche Sätze raus. So ehrenwert auch Herr Parsons ist und auch die Versuche, Weber ins Englische zu übersetzen. Also ich hätte ja gerne auch in Deutsch gesprochen, so ist das nicht, aber die Tatsache, dass wir zumindest einen Zuhörer in diesem Raum haben, der des Deutschen nicht mächtig ist, verpflichtet uns alle dazu, ça nous amène de chercher une langue dans laquelle nous pouvons communiquer. Il ne faut pas se sentir coupable de rien. Ça, c'est l'éthique communicationnelle qui est tout simplement demandée dans ces situations-là. Alors, ich werde mal jetzt übersetzen. Die universelle, nicht übersetzen, vielmehr den Weber ursprünglichen Text, also nicht, aber wenn man das jetzt rückwärts übersetzt, das wird schlecht. Die universelle Herrschaft der Marktvergesellschaftung verlangt einerseits einer rationalen Regeln kalkulierbares Funktionieren des Rechts. Wo dies chaotisch ist, das kann man ja auch durchaus sich vorstellen, wird es außerordentlich schwierig, dass Marktreflektanten in irgendeiner Weise sich koordinieren können. Und andererseits begünstigt die Marktverbreiterung, die wir als charakteristischer Tendenz jener kennenlernen werden, Kraft der ihr immanenten Konsequenzen, die Monopolisierung und Reglementierung aller legitimen Zwangsgewalt durch eine universalistische Zwangsanstalt, durch die Zersetzung aller partikulären, meist auf ökonomischen Monopolen ruhenden ständischen und anderen Zwangsgebilde. So that means there is an interaction. On the one side, market structures need predictability and a kind of universal law on the one side. But this tendency to universalization means also the rise of centralized state institutions that will, on the other hand, so to say, suffocate other normative particularistic orders, so that there is a logic of built-in market structures as such, as Weber says, to universalism in legal orders. This is, I think, the most interesting point in this quotation. Finally, the functional equivalency of legal regulations, institutions, and patterns of thought as brought about by different legal systems, is investigated purely from the perspective of the effects they produce on the predictability of law for the economy. While legal guarantees often serve economic interest, the extent to which economic actions can be directed by law is subject to the inner barriers of any kind of forcible application, as well as the inherent laws of economic motivation to act. Their aim can be to precisely not neglect economic chances for the sole reason of being able to act legally, especially when legal particularism is promoted by competing political associations. When comparing historical legal cultures, Weber argues that the state is by no means the sole legal guarantor of economic interests in general. That's very clear. Tribes, clans, and the like protect property, and chattel money can also be shown to exist in the absence of state guarantees. This would only be the state theory of money that would link it to the existence of a figure, of a structure like the state. In a society that increasingly communicates through contracts, however, the state guarantee of private legal claims becomes even more important, despite the tradition of contractual legality, pacta sunt servanda, for reasons of the loss of faith in its sanctity, as Weber explicitly states. In my class yesterday, we spoke about pacta sunt servanda and the question in how far it really is out of debate and how sacred this basic sentence of the private law can be looked at. With this focus, the text goes beyond the context of a former text by Weber. The Weber specialists will know the Logos essay, where especially he brought forward one major idea and fundamental for understanding the way he looked at the social world, namely the idea of Einverständnis, very difficult to translate very often as consensus, but meaning the fictionality and the causality, and that fictions may be causal in the sense that interaction in general is not possible because we would know exactly what the other, ego and alter, would think and imagine about the other's way to look at him, her, or to look at the world, but to live with the fiction that this kind of mutuality would exist. And this is the kernel of Einverständnis. And there Weber is playing and dealing with a philosopher, Feinger, die Philosophie des als ob eine Vergemeinschaftung bestehen würde. Und dieses ist, and this is for Weber very important for an understanding also of economic life and the law in general. So this was a little bit a reconstruction of die Wirtschaft und die Ordnung. Much more had to be said. I would recommend you to have a look into, if you take the Studienausgabe, I don't have it with me, but the third chapter of die Wirtschaft und die Ordnung, where the limits not to growth but to the coercive power of the law vis-à-vis economic life is very, I think, very consistently formulated, though it is not the whole story, as we will see. And please let me say something in a more general way about Weber, economy and the law, though it seems to be so fundamental because Weber referred to the four mentioned Stammler. If you take the composition idea of die Wirtschaft und die Ordnungen and the Rechtssoziologie, you will see that two composition ideas, one of 1910 in the so-called Stoffverteilungsplan, is conflicting with another composition idea of 1914, the so-called Werkplan. This is philology, but you will see how important this kind of philology is. Because in the first plan, Weber wanted firstly to write a part about Wirtschaft und Recht. Subjacent point. In ihrem prinzipiellen Verhältnis, first one, and secondly, about the epochs of its development. Wirtschaft und Recht, erstens in ihrem prinzipiellen Verhältnis und dann Epochen ihrer Entwicklung. And we have in Wirtschaft und Gesellschaft two manuscripts that I had the pleasure to edit in the historical and critical edition. So they can be attributed to those 2 points. Wirtschaft und Recht in ihrem prinzipiellen Verhältnis, later named die Wirtschaft und die Ordnungen. And then on the other side, something like Entwicklungsbedingungen des Rechts as the plan of 1914 called the part about the law and the evolution of the law. It is no longer epochs, it is Entwicklungsbedingungen, conditions of rationalization meanwhile, between 1910 and 1914, it became more and more clear for Weber that for the evolution of a sphere like the legal sphere, it would be so important not to lay stress only on its inner logic, its innere Gesetzmäßigkeiten, but to see how other spheres intervene in a direction that is so in the way to become more rational, at least in Occidental societies. And this means religion, other factors had relations to imperial powers, to political systems, etc., had to be taken into consideration in order to understand this multifold process of Occidental rationalization. And so this means that 2 compositional ideas, on the one side fixed on the relationship of Wirtschaft und Recht, and then to understand what law in general would characterize as a rational law in comparison with Islamic law, with Judaic law, with Roman law, even elements of Roman law, Greek law, papyrus law, etc., etc. What really would make the specificity of 1900 German pandectistic legal culture as the culminating point of a rational law would be, and what kind of factors, inner factors and factors from the outside led to this. So this became the main topic, so that Wirtschaft und Recht no longer was the main question. His ideas and incredible knowledge turned around. And this poses a problem in reading. It makes the reading difficult. And it leaves, in the end, the question that we have, even for those who may have an idea that Weber's reading might be interesting, is in the end not so fruitful as we might have expected. And that there is a double leg. On the one side, in culturalizing economic life and seeing economy through the eyes of the lenses of cultural studies, and to bring it together with the evolution of legal systems. So I think that is why also, not only because it's 100 years ago, exactly when he was asked to become a professor in Bonn in 1918 and 1919, and he refused because he preferred to go to Munich for personal reasons in the end, I would say, as we know. So this means there is a big really a big champ de recherche, even if we might, in general, be on Weber's side. Do you understand why I started with this point? And I come now to the second part of my talk that deals with economy and law through the lenses of culture, or with the general title, one may call it Culture Matters? Open question. It is the basic premise of this center that law cannot be looked at using only a juristic lens, but must also be seen through the eyes of the humanities, especially the kulturwissenschaftlichen, unfortunately not entirely congruent with the term cultural studies. The law as culture paradigm praises an enlarged concept of the law, including symbols, rituals, organizational structures, and narratives that go beyond the normative scope of decisions and statutes. It proved, too, that a relationship with the religious field is fundamental for understanding law, as law, too, competes in modernity for scarce resources to be untouchable, even sacred, and delivering identity, collective identities. The universal observation of globalization does not exclude the legal sphere. Rather, the law holds the potential to heal some of the consequences of globalization or create new ones. Conflicts of legal cultures resulting from the spread of a judicial scape beyond the nation state is crucial for understanding today's world. But without relating the law to aesthetics, neither some inner juristic items of the legal system, like questions of style and the beauty of a decision, might remain unremarked, as well as the symbolic power of the representation of law in marbles, stones, on canvases, and installations in order to improve the force of law, la force du droit, might be underestimated. However, the irritating question remains whether a cultural turn in legal studies might not promulgate culture as a normative argument, allowing for cultural defense, cultural restraint, and the cultural founding of legitimate and legal differences regarding the decision of what is right or wrong for the whole society. So that was the program of the first 6 years of the center, the first phase, that I was just resuming, in other words. But what about economic life? Culture does not have a good reputation, as you know. You should wake up, my dear, when it is about culture. It is often linked with only high culture, excluding the culture of everyday life, or it is, especially from the perspective of economists, looked as specifically soft matter, merely left to literary men, poets and women, of course, and not the tough guys in science, economics and society. Regarding economic life, few leaders would deny being personally interested in cultural matters surrounding themselves and their enterprises with beautiful things, rather expensive sometimes, even looking at the aesthetic quality of their products and the good tradition of the arts and craft movement, a perfect web and product design, etc. However, who would explicitly maintain that culture is a precondition for economically efficient action, a means of production, even a fundamental resource of productivity? And who would go so far as to say that culture does not only matter, but that culture pays, measurable in dollars and euros? I would like to put forward this point by showing that culture matters in the second part, and this goes back to experiences in a project I could make with telecom. So culture is seen as the contextual variable of any economic action at different levels with regard to values, beliefs, basic attitudes toward the world, at whatever level we look at economic life, as a frame of reference in the economic exchange between different cultures, representing Successful cooperation as well as economic failure, we know very well. If you don't understand that in some regions of the world it's better to make a handshake than to make big contracts, then you're really lost. You may leave it then afterwards to your to your lawyers, but please first be able to make a deal. So you have to act, and if you don't have understood this fundamental aspect for making so it's a B. Thank you. She's coming with me, and I will first of all kill her in presence of and she's gone. Really? Okay. Of course, this is not irritating, but it is. I don't see it as a personal attack. I see it from a very cool point of view. So, an element of conflict and misunderstanding within multicultural settings also. So, if you haven't got this point, you might be out of the debate. And sometimes I got the impression that, especially from Germany, it took a long time to take it for serious, that cultural information is a productive force in intercultural interchange. If these propositions are true, veritable entrepreneur should above all be specialist in culture. So that's what I proposed at the time, and some were fascinated by it, but not all economists would agree with such a proposition. Though I'm not sure I will be able to convert all those. I'll do my best, of course, also during this I wanted to say this class, but this talk, to add one necessary preface. The separation of culture on the one hand and economics on the other is certainly an oversimplification due to analytical purposes. The economic sphere is, of course, part of the objective culture, as Simmel once said, and it is one of the main culture-producing forces in a society. The art of advertising, the spread of product-related lifestyles impregnate a whole culture. Culture is a necessary side effect of economics, if you will. The question is, does culture matter also in regard to economic interests? Or is the economic outcome solely the result of economic reasoning, of rational action, independent of any cultural impacts? This is the simple yet difficult problem that underlies our debate of law and economy when both are seen through the lens of culture. It doesn't make sense if we are not able to make a notion, an idea of economic life that is out of the cultural perspective. Be it from an economist or jurist point of view, one must define what culture is and what is to be understood by culture. That is the meaning of the term culture, its propensities, functions, and effects. So you will shudder that I will really touch this very difficult problem, but only in some words. Don't be afraid. The meaning of culture, or the culture of cultural studies. That said, one of the strongest arguments against cultural theory may be raised in pointing out that the actual term is badly defined, an object of salient controversies. Professor Albrecht knows better than me from the German debate how many notions and aspects had been thrown in the air. In other words, it has been more a resource of intellectual conflict than one of consensual assessments, one could say, at least for the discourse structures. Let me say a few words on this controversial point. You should know at least what my idea is. It is true that the meaning of culture varies according to disciplines. We speak about legal culture that transcend the pure contempt of legal rules. We speak about criminal cultures as systems of practices and value orientations in juvenile delinquency and white-collar crime. And we would not refuse the label of culture to an orchestra and its specific culture of playing Beethoven, for example. Moreover, we distinguish between different learning and research cultures in Germany and France, Great Britain and the United States, etc., and different traditions of innovation. We discuss the necessity and legitimacy of elites, etc. These examples reveal the common trait of culture as I try to understand it. It is not a question of high or low, valuable or pickable culture, but rather something we do not choose, like our language, which we use by default, if you will. It is something that is out of our immediate control, provided as soon as you are born into a society, a social system, a social interaction. It has to do with tradition as the non-reflected condition of action, as Habermas called it, was sich im Rücken der Akteure abspielt. And it is composed of distinguishable elements, symbols such as language, norms of behavior, and formal and informal rules, as well as rituals and routine forms of social action that discharge the actor from permanent reflection, thereby creating, when practiced in common, some collective feelings to produce solidarity and effervescence among those who adhere to the respective commonality and community. That's at least a way I try to understand it. In simple words, I'm summarizing the cultural theory of Emile Durkheim, the founder of French sociology embedded in the cultural traditions of France, the motherland of social sciences in the 19th century. To him, symbols, normative rules, and rituals established the core of the religious field, the elementary forms of religious life, as he called them, and as we now use them to conceptualize the realm of culture. While in Durkheim's approach, descriptive power emerges from the combination of a reduction of cognitive and emotional complexity in symbols, the limitation of action by norms, and the dynamics of interaction in symbolically guided rituals, Max Weber devoted his concept of culture directly to ethics. Kulturwissenschaft in German cultural tradition is not only opposed to the study of nature, but it presupposes a certain quality of man in general, namely to be a Kulturmensch, endowed with the capacity to take a stance in the world and assign meaning to it. I think this is a very important point. Stellungnahme und der Welt einen Sinn zu verleihen. So I had prepared Max Weber and culture. I just quote this a really important sentence. Transzendentale Voraussetzung, vielleicht meint er transzendente, ich weiß nicht so genau, jeder Kulturwissenschaft ist nicht etwa, dass wir eine bestimmte oder überhaupt irgendeine Kultur wertvoll finden, sondern dass wir Kulturmenschen sind, begabt mit der Fähigkeit und dem Willen, bewusst zur Welt Stellung zu nehmen und ihr einen Sinn zu verleihen. So this is also the ability to be a religious man, because this also means take a stance in the world and to impute a kind of meaning into the world. Kultur ist ein vom Standpunkt des Menschen aus mit Sinn und Bedeutung bedachter endlicher Ausschnitt aus der sinnlosen Unendlichkeit des Weltgeschehens, in other words, by Weber. The constitution of culture is therefore the product of social actions in this reading. Giving meaning to the world is the result of cognitive acts, completed by empathetically evaluative acts of taking a stance in the world. This is why culture is constituted by way of acts, even if it is not always reinvented from scratch everywhere. So I think this is an important point I wanted to link to the Weber's Weberian concept of culture and cultural studies. Culture and economics. Looking at the conception of culture as a creative force in social life, it would not be surprising to detect it as a productive force of economic life, as I said before. However, the pure and sometimes poor economic paradigm tries to explain social life and actions according to the pursuit of self-interest and social structures, including economic ones such as markets, which are depicted as the intended or unintended consequences of rational behavior. So I have here a longer part where I dwell into those debates, but I think I really wanted to stay under the very sharp level of 1 hour. That is really the limit I have permitted myself to speak, so I have only 15 minutes now, if I see right, or perhaps 17 minutes if you are so kind to remain with me. That, for example, parts about a culture of rationalism as being an explicative variable in understanding and bringing together social action, communal action, and the outcome of economic structures have to be let aside for the moment. So if I had to summarize, economic rational action is embedded in a cultural frame, infecting the economic principle itself with a view on the world often religiously impregnated and shaping the different cultures of economics. What is the connection between this very fundamentally insights mostly neglected by pure economists and understanding and explaining the complex interaction between the economic and the legal sphere? That's the final question for my talk. So I come to the last point, some consequences of reading law and economics as culture. The main thesis of this lecture asserts that the double cultural turn in the study of law and legal practices in the realm of normativity on the one hand and in the analysis of economic actions, processes, structures of economic life on the other hand, has not yet been transformed into a revised vision of the old-fashioned question of law and economy. That's my thesis. Law must be seen as a multi-dimensional practice composed of symbols, rituals, organizational structures, norms, narratives, and some other elements. A practice of structuring the order of social spheres. At the same time, it is the medium of communication within social spheres and competes with other normative orders like habits, customs, fashions, etc. Insofar as the constitution of society, so I come to the second point, imposes a certain type of relationship between politics and economy, for example, by forbidding an amalgamation of the spheres through corruption or state actions in the economic field, there is also a very fundamental relationship between economy and the law. The inner structure of economic life, third point, is likewise ordered according to basic principles like property rights, private economy, autonomy, the regulation of the market, delivery of types of economic action using a set of typical forms of contract, very often derived in the end from the Roman law typology, except the case of the leasing contract that the Romans did not foresee and at the time, risk management, etc. Situating the place of law and economics in society has changed in the history of mankind and in comparing civilizations. I have left it out this point. Of course, this is very fundamental. There can be no doubt that law and economy is embedded in civilizational context. Max Weber's analysis, fifth point, of the role of religiously impregnated worldview stands for such a tradition. Unfortunately, his principal analysis of the relationship of Wirtschaft und Recht, which drew upon the highly criticized Rudolf Stammler, as we have seen, has not yet been fused with his historical and comparative studies. The process of rationalization of the law in the Occidental world is due to a complex combination of intrinsic and external conditions for the evolution of the law, where the religious factor, as analyzed in Judaism, Hindu society, antique societies, Islamic cultures, and Protestantism, plays a major role. At the same time, there remains the analysis of economic development, mainly going the same direction of rationalization by way of specific structures, typical of capitalism as an economic order, not to forget Weber's analysis of the stock market. But at least, to my understanding, these two strands have not been adjoined in the sense of comparatively analyzing the encounter of those two spheres in their specific civilizational contexts. Sixth point. Beyond the reconstruction of Weber's perspective, you like it or not, of course, one can do a lot of things in research and may feel inspired from a lot of inputs. A look at some cultural turns in the sociology and anthropology of economic life must be noted, and this comes now. A rereading of Simmel's and Durkheim's writings, as well as that of Marcel Mauss, in the light of cultural sociology of economic life, seems to be promising. 2. Simmel's ingenious insights into the colors of money that we have seen before in one image could be combined with Durkheim's analysis of the role of symbols play as a basis of society, looking specifically to the division of labor in society and the role of differentiation in Simmel's early writings, which would create a bridge to current ways of theorizing die Wirtschaft der Gesellschaft, as Niklas Luhmann has tried to do it. 8th point. Oh, sorry. This is Marcel Mauss. Frédéric Le Baron's, I don't know whether you ever had a look at this into his writings, croyance économique. So that means a belief system. Economy as a belief system, as a religion. May draw a line from the Durkheimian tradition to Deutschmann's identification of sacred traces in a market economy so familiar for Simmel's use, once again, of the figure of religioide forms in economic life. In this new image, 9th point, of economic life, the structural features that for some time were the main purpose and the main interests in Wirtschaftssoziology, sociology of economic life, must not be excluded, but rather related to the culture of economy. Weak and strong ties in creating jobs, the famous Granovetter thesis and its critique by Ronald S. Byrd as structural wholes, the deconstruction of the market as being the outcome of constructions and not a real place where we would exchange, like in medieval times or wherever, when we sell a car, and not an autonomous mechanism. Ethnographic studies about the Sicilian mafia and other institutions that dwell in their illegality, but maybe economically very successful. The question how to name the new forms of capitalism is one of the big problems and the big questions that are raised. No simple answer. Luc Boltanski and Yves Chiapello evoke a new spirit of capitalism. Paul Windolf proposes the capitalism of financial markets as the new face of capitalism. Deutschmann looks for new capitalist dynamics. There is a rather big market how to name the new capitalism we live in. It is surprising how weak and rarissime references to both rules and normative orders in general, as well as to the legal sphere, has been defined. I take one example, a very interesting and fine collection edited by Klaus Kremer and Florian Brugger, titled Schlüsselwerke der Wirtschaftssoziologie. There you find really very important articles and the fundamentals and this new discipline, I would say, in a way, morals, but they don't speak about the law, normative orders, morale a little bit, yes, you must do that when you speak about the market, but for the rest, there is no systematic analysis of the role of the law for understanding new economy and new economic life. Morals and market, as I said, is a well-known topic, and framing finance, for example, has been treated, among others, also, once again, by Weber in his Börsenschriften. Boltanski's and Thévenot's readings of La Justification, however, contaminate the founding of economic practice, insofar as economic action also has to be justified, whether by religion or something else, but it is part of at least one of those cités by which this kind of society has been constructed. A new paradigm of relating Wirtschaft und Recht nach der kulturwissenschaftlichen Auffassung, as I tried to propose it, had to take into account those developments that, at least to my mind, are not yet integrated into a comprehensive theoretical framework. Whether the metaphor of sphere, so I put Weber into a sphere, Bourdieu with the field, so he's looking so friendly to us, and in the background there, the field. The problem is, how do you go from one field to the other? You have to bridge, and you have to cross just a border, and I think the world is a little bit more complicated than this way to think the world. And Niklas Luhmann, as the magician of sobriety, also Magier der Sachlichkeit, has a less concrete and more abstract idea about this. But however, one had to discuss what kind of type, what kind of images we might have in our head when we think about the interrelation of those two worlds, two spheres. Perhaps we don't need it. So much the better if you're able to do that. Some people need images in order to be able to think. Law as culture, therefore, enters a complex interaction with the economic sphere, as law is not only to be analyzed as limiting condition to rational economic action, but as an independent symbolic and ritual reality within the places and times of justice that seek to fence in economic action its institutions of market activities, the production and distribution of goods, the symbolic and ritual spaces of mammonism, the temples of banks and virtualized stock exchanges, and so forth. The transcultural export of institutions is now here as conspicuous as in the economic line of globalization, legal transplants debate. But we misunderstand the cultural scientific access to the economic sphere if we only evaluate it according to the aspect of culturally determined boundaries to economic rationality. Shadow economies, economic action within the Davaru area in Mumbai are based on distinct cultural preconditions and produce their own norms that can be found within the wider societal frame of the regulation of non-regulated living, so in slums that can be defined this way. A deeper understanding of this founding relationship appears also fruitful. In the context of the law as culture paradigm, the following research problems therefore stand out. Unfortunately, Raphael is not with us, who is working about transforming law and economy in transitional societies. That's his specific expertise. Explaining the crisis of 2008, 10 years ago, when bubbles bursted as an implosion of social spheres, as I tried to analyze it, and the rules of the market as a game, a construct, and a myth. If, for instance, we were to inquire into the legitimate expansion of market logic and understand law as the demarcation of limits to boundless law of the market, then it would become apparent that the marketability of goods and values cannot be conceived outside a civilizational context. The prohibition of taking interest in Jewish and Islamic discourses on economic ethics is a classic example. Some years ago, Raja has written about das Verbot von Zinsnahme und Risikogeschäften, Theorie und Praxis islamischer Finanzethik, and we had discussions in our center with former fellows about this interesting thematic and problematic. Where the lines can be skipped for money, doctors' appointments should be purchasable, trade in blood or organs should be permissible, the devaluation of securities should be monetizable, etc. Counteragents and the setting of limits through norms are all tied into cultural contexts that need to be decoded in the light of how the respective differentiation program of a society is shaped. So I think this is, again, one of the main keys to understand those difficult questions. If you, or put it in another way, if you are not aware and have not a sensibility for differentiation behind, then I think it's even more difficult to have access to those problematics. So do we have ideas for a renewed understanding of money, or into the nature of money, or the intentionality of money as a specific declaration act, as John Searle tried to convince us? Some years ago we had this debate with him. The legal ordering of a new digital world is at stake. Internet contracts, virtual societies, real contracts. Does globalization through the internet cut across national boundaries, not only in everyday communication and business affairs, but also in normatively framing digitality? And what kind of juristic answers do we have to those processes? With regard to the challenge of the humanities by way of the arts, a constant feature of the Law as Culture project at the Käte Hamburger Center in Bonn, the following question arises: what can be learned about the relationship of law and economics when the legal order allows for an artistic project like Maria Eichhorn's stock company as a legally valid Aktiengesellschaft, symbolizing the frozen dynamics of capitalism or the invention of a proprietorless property in her Athens project during last Documenta in 2017. Unfortunately, she's not with us today because she's in a commission of the Edvard Munch Society, and there she was absolutely demanded to go. So she is not with us. But if you have a look into the forum program, you will see 27th of November, the following month, we'll have a Künstlergespräch with her, and you should try to be with us. And I'm very glad that Anne-Marie Bonnet will be with us as a fellow and a specialist in her art, and also to put the right questions to the artist. 27th of November, don't forget it. I come to my conclusion, and still I have 17 seconds, it will be a little bit more. Let me resume by again formulating the general question that provoked us to take the risk of running into all the traps of an unresolved riddle in the history of the humanities. Why is the complex relationship between economy and law a fixed purpose of both economic and legal analysis? And why do the humanities and cultural sociology remain so oddly silent on this issue? In modernity and its accompanying theoretical discourse, law and economy seem to inevitably part from each other, for determining the law based on client or class interests would conflict with the notion of a general law standing above all parties and the ideal of universalistic justice. An economic sphere that has not freed itself from outside influence through traditional orders could at the same time not even develop autonomy. Nevertheless, we know of complex sets of conditions and independencies, even if it appears impossible to derive concrete legal forms or legal institutions from their economic relations, or reduce economic activity and its meta-reflection to their judicial forms in the conceptuality of economics. Although the categories of law, contract, property, societal features, etc., have impacted strategies for conceptualizing in economic theory, we think that this kind of reasoning is neither game for the leisure class, as Thorsten Veblen has resumed his observation on capitalist behavior, nor it is neither a kind of luxury, I would say, as Werner Gephart tried to characterize modern capitalism. However, we also long for some kind of entrepreneurship in Schumpeter's sense, who in the end was a professor at Bonn University, more realistically than Weber's imagined commitment that led him to Munich instead of Bonn, unfortunately. That's the end of my talk. Thank you very much for your attention.